All right, let's see who's up first. Fallahy and Navarre. Shooty and Terranova, are they in there? Let's just see. Nope. And let's see if there's any Freemans. Okay, Shannon, could you put us on the record?
I sure can.
Freeman versus Freeman. Are either of you expecting clients?
Your Honor, my client, I think, was going to appear by telephone today.
Mine as well, Your Honor. Good morning, Your Honor. Morning, Mr. Fallahy.
Morning, Phil.
I have one unidentified cell phone that I will allow in just to see who that is. And we're struggling to make a connection. And I've got an unidentified iPad. We'll let that in too. It just showed up.
Morning, Mr. Freeman.
He doesn't have an audio connection yet. All right. And let's see who's on this Galaxy. That's the one that's struggling. If you've got the phone number, I can try dialing it, but I don't see anybody in. Everyone else is identified. So if this isn't your client, Mr. Fallahy.
She might be in now, Your Honor, if that is her on that Samsung Galaxy.
I'm not getting a connection.
No connection? Okay. I do have her.
Yes.
Oh,
Go ahead and give me the phone number and I'll dial it.
thank you. 914-4218.
Oh, I can hear you now, guys. What did I do wrong?
Oh, okay. Is this Ms. Freeman?
Yes, I can hear you now. I'm so sorry.
That's all right. That happens. Okay, we're here for entry of an order or an objections to an order. So let's see. Defendant objected. What is this, the objection? I didn't get a chance to look at this ahead of time.
Judge, if I may, thank you. We timely filed objections to proposed order that was submitted by plaintiff through her counsel under the 7-day rule. And those objections were filed on July 28th. And on that same date, courtesy of opposing counsel, I received those objections or the proposed order by email as well. But that proposed order does not check, it leaves unchecked box number 4 on the USSO, page 1. And box 4 says, for tax purposes, the payments will be deductible to the payor and includable in income to the payee. And so their proposed order leaves that unchecked, which then makes it non-deductible to my client under the Tax Cut Jobs Act legislation, which is now law. And that's not what your honor ordered. That's not what your ruling was. The other thing that we objected to was that the payments be directed through the friend of the court through an income withholding order. On paragraph 11 of our proposed order, we have language which says as follows. Payer shall pay spousal support through an employer payroll deduction of $200 weekly through an electronic funds transfer into an account with plaintiff providing a designated account number and bank routing number to effectuate such transfers, which shall continue until further order of the court. Payer owes $225 in spousal support arrearages as of August 1, 2020. Payee shall sign an affidavit of direct pay credit in the amount of $225. Attached to our objections is a photocopy of a check which is drawn on my firm, made payable to the plaintiff in the amount of $225. That has not been tendered because it's my understanding she wants everything to go through the front of the court. Judge, my client's position is this. Number one, you did not order a change in the tax status. You said, I believe, that there wasn't really sufficient basis for modification. He was able to make $200 a week payments, and you wanted that to continue. Your Honor, the court's prior order was through a default judgment for the spousal support, and that judgment qualified payments to plaintiff from defendant under Internal Revenue Code Section 71 as Section 71 payments, being that they were alimony. And so for tax purposes, they were includable in income to the plaintiff and deductible from income to the payer defendant, Mr. Freeman. The court's ruling after the evidentiary hearing didn't order a modification in the tax status of spousal support payments. Their proposed order, which we filed objections to, changes that tax status. The court indicated again that the defendant's situation to modify the $200 weekly payments hadn't changed. He had the ability and demonstrated through past performance to come up with $200 a week going forward. Your ruling indicated that the $200 weekly payments were to continue until payee's election to collect Social Security or payer's eligibility date for full Social Security benefits. So my client anticipates more than 5 years he'll be eligible for full Social Security benefits. He's ordered to pay $10,400 annually to plaintiff. That's $200 a week. His effective tax rate in 2020 is 22%. Plaintiff's effective tax rate for 2020 is 12%. So the proposed order that we filed objections to increases my client's expense annually by $2,288 at the 2020 effective tax rate of 22% for this tax year. So if his effective tax rate remains constant until the defendant's anticipated eligibility for Social Security, it costs him more than $11,440. Judge, you didn't order that, and that's why we objected. It's our position that he's entitled to maintain the status of the prior order contained in the default judgment of divorce. And it's our position that plaintiff inappropriately seeks a windfall by including in the proposed order a tax status change not ordered by the court. Plaintiff further seeks payments through the front of the court, which will necessitate service charges to my client, which were not previously incurred. The court didn't order that the payments go through the front of the court in its ruling after the evidentiary hearing. We object to payments being made through the front of the court as he's going to be charged service fees for that, which are not necessary. The parties both testified at the evidentiary hearing that the only payments missed by my client were for the months of April and May immediately following his 2015 open heart surgery. Now, granted, Your Honor, my client did stop paying in 2020. He felt that he had paid enough. It was not appropriate to do that on advice of counsel, but we addressed that by filing the appropriate motion to modify spousal support element. So we've offered, and she's refused to accept the payroll deduction payments transferred from his employer to an account that she would designate by a weekly EFT. My client estimates that the service charge to the front of the court is going to exceed $500, which is unnecessary. And he's not opposed to an order which provides a $200 a week payroll deduction by his employer and deposited into the designated account by plaintiff through an electronic funds transfer, and that continue until further order of the court. And so that language, which I have on our alternate proposed order in paragraph 11 on page 2, that language would have a similar effect to an income withholding order, but without the additional expense to my client. So the court found after evidentiary hearing that my client was entitled to overpayment claimed and was applied to his arrearage. And the court determined that as of August 1 of 2020, there was a $225 arrearage. My client's deposited funds in my account. I've cut a check. We attached a copy of that. We're ready to deliver that in exchange for direct pay credit. So, you know, plans refused to authorize the submission of our proposed order, which maintains the status quo of the taxability of the payments. And so she insists on language modifying and changing that was not ordered by the court. It's our position.
Mr. Navarre, I understand your objections. Mr. Falley, can I hear from you?
Yes, thank you, Judge. I'll fly through these issues real quickly here. Judge, your ruling from the bench and my proposed order that I submitted on behalf of my client comply with the law. The Tax Cuts and Jobs Act of 2017 indicates that, well, it essentially eliminated the tax deductions on alimony for divorce orders that were entered on or after January 1, 2019. This case and your ruling was after January 1, 2019, and the court was silent on the tax status in its order from the bench after our evidentiary hearing. So it's our position that your ruling complies with the TCJA of 2017. I don't know this for sure, but I think that I don't think either party has historically deducted or included the income despite the language in the prior order. And you know, Judge, I'll remind you that the reason we were here is because Mr. Freeman decided to unilaterally violate the court order and stop paying, which required my client to file the motion that she did. So it's our opinion that our proposal.
So let me stop you. Regarding the impact of the TCJA, if that's what the law says, and I'm entering a new order now, how can anything you put in the order impact the tax treatment as it's been modified under the TCJA?
Your Honor, if I may.
Go ahead, Mr. Navarre.
Thank you, Judge. Judge, any subsequent order, if it preserves the pre-existing tax status, maintains that. It's clearly stated in the law. It's clearly stated in the TCJA. And so it wasn't something that changed all orders which entered that were effective prior to the effective date.
I heard you, Mr. Navarre. I don't have that provision in front of me. I've got you representing what it says. I got Mr. Falley representing what it says. It's not in front of me. How am I supposed to rule on the impact of that and whether or not there's anything I can put in an order that'll change it without seeing what it says?
Okay, Judge, I can provide a short memorandum of law or brief if that would help the court.
I think I need to see that.
That's fine, Judge.
Don't I?
I can provide that. I can provide that.
Okay.
You want to set this
So
over?
I'll wait until I get that before I make any. I clearly did not address that. It wasn't raised until this proposed order and objection were filed. I haven't had a chance to consider that. I'd like to take a look at that. Mr. Falley, could you address the other objection where the desire is to put to do this outside of the friend of the court to save fees?
Yes, Judge. You didn't order that, and I would point out MCL 552.604 to the court, which indicates every support order must contain income withholding language, regardless of whether the payer has a history of support arrears. So it's our position that, again, the court's ruling was consistent with the law, and our proposed order was consistent with the law on that. This is just something.
What I'm understanding, and clarify if this is incorrect, what Mr. Navarre is saying is he's okay with an income withholding order. He just doesn't want it to go through the front of the court. So,
Yeah, and I agree with that. However, the reason again that we were here is because Mr. Freeman had some level of control over these prior payments, and they stopped. And so my client wants the protection so that she doesn't have to come back before the court, have to go through this again. She's now spent thousands of dollars in attorney fees, and Mr. Freeman is now paying more than he was ordered to pay before. So had I mean, none of these issues would even be issues if Mr. Freeman would have continued following the court order as it was ordered, and he didn't. And so my client wants all the necessary protections to try to prevent this from happening again. And the safest way to do that, from my client's perspective, is to have those go through friend of the court, have the friend of the court do what it always does in these types of cases, pursuant to the Uniform Spousal Support Order that was approved by the SCAO, which is income withholding through the friend of the court. I mean, obviously, if the court orders that it's done through an EFT with the employer, then we're going to live with that. But what I'm getting at is the court did not order that. And so Mr. Navarre and his client are trying to add something into an order that wasn't ordered. And that's not appropriate. And then they try to turn around and say they want attorney fees because my client and I put in the order precisely what the court ordered. So I'm failing to understand their request for attorney fees. Obviously, we would ask that that be denied. My client has no problem with acceptance of a check for $225. If Mr. Navarre wants to mail that to my office, along with the affidavit, I'll ensure that my client stops in and signs the affidavit. I'll send that back to Mr. Navarre for filing with the friend of the court. So that's not a big issue, but we'd ask that the attorney fees be denied, or potentially that the court consider an award of attorney fees to the plaintiff. And I guess after the court reviews the law under the TCJA, enter one of the orders, and we can be done with it.
what I would be willing to add, since what Mr. Navarre is requesting on behalf of his client will save his client some fees through the front of the court, is that in the event the defendant does anything to disrupt that wage withholding order, necessitating a further motion, that I would certainly award attorney fees under that circumstance. That should satisfy your concerns about that issue. I'm not going to be awarding any attorney fees today to either side. I don't think that's appropriate. I think it's a legitimate objection, at least with respect to the box that was checked. I see that that box was checked in the original spousal support order, but I want to make sure I understand the impact of the TCJA before I rule specifically on that.
Okay, thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
And Your Honor, for scheduling purposes, I understand that you're going to be off the bench for a period of time.
2 weeks.
Should I just get with Dawn to schedule further hearings, not on this matter, but on other matters? How far out are you scheduling?
I'm gonna be gone for 2 weeks, starting August 24th.
Okay, thanks, Judge.
Thank
Your
you.
Honor.
That concludes my matters, Your Honor. Have a good day, Your Honor.
Likewise.
Thank you, Mr. Fallahy.
Thanks, guys.
Okay.
I just got the giggles again today. Can you hear me?
Okay, next up is King versus Sharp. Counsel, state your appearance, please.
David Jones appearing on behalf of Robert Sharp.
Okay, Mr. Sharp is present on the Zoom hearing, as is Ms. King. Is there anyone else participating in this hearing to anyone's knowledge?
It should be Christopher Holbrook as guardian ad litem for the minor child.
Okay, I'll let Mr. Hurlbert in. Good morning,
Morning,
Mr.
Your Honor.
Hurlbert. Okay, Mr. Jones, this is your motion.
Yes, so as the motion
Just
states,
a second, sorry. No,
No? Okay. Thank you.
I'm sorry, go ahead, Mr. Jones.
yes, as stated in the motion, in the consent judgment of custody that was signed on May 16, 2018, there was 2 requirements for Mr. Sharp to do before the court could order supervised parenting time. The first was that he signed medical releases for, it was Mr. Finley at the time, but Ms. King is now unrepresented, and Mr. Holbrook, the guardian ad litem, he has signed those medical releases. The second requirement was that he start psychiatric treatment. He has now started psychiatric treatment. He started that back in December of 2019. So given that those 2 requirements are done as requested or required in the consent judgment of custody, I believe it is appropriate to start supervised parenting time at this time.
May I speak?
Yes, Mr. Hurlbert. Oh, I'm sorry,
I didn't
Ms.
ask
King,
that.
that was you. Pardon me.
That was me.
Go ahead, Ms. King.
Robert was also to get a psychological evaluation, and he failed to do so with Dr. Hand. He left the evaluation abruptly and angrily, and the Child Protective Service worker on the case drove him to that appointment, and he left before finishing. He was angry. So he did not complete the psychological evaluation. Also, is he seeing a psychiatrist or a social worker? And what is the determination based on his self-reporting?
Mr. Hurlbert?
Thank you, Your Honor. First of all, Ethan's doing fine. Never had any issue with him in his mother's care. He does have allergies, but mom's on top of it. He's learning how to swim underwater, walking, talking. He's hitting all of his appropriate milestones. Your Honor, when this motion first came up back in March, which seems like a lifetime ago, I did speak with Mr. Sharp's providers, and I was encouraged by what I was hearing and what I was reading from the letters that I saw. And then before we came to court, I received some late discovery. It was rather disturbing about an interaction that Mr. Sharp had with his daughter, his other child. So the morning of the hearing, I shared that with Mr. Sharp's attorney, and I guess he shared it with Mr. Sharp. I wasn't obviously watching. He was meeting with his client, but after that, Mr. Sharp left. We didn't go through with the hearing, and he did not just walk out pleasantly. When I was speaking with one of the therapists, the phrase that was used is he's turned a corner. And that's why I was encouraged that we were getting to a point where we're seeing something. But then reading about the interaction with his daughter and seeing the reaction at the courthouse, I was wondering who these therapists have been seeing. It's just not the kind of behavior that we've witnessed, you and I, in court, and me even longer with other judges. My concern is that, yes, it's nice to have finally, after all this time, gone through the steps of signing the releases and all that, but that kind of puts the horse before the cart, because the idea was that that would give the court some information that the court could then determine whether we should have parenting time, not just go through some hoops and we'll automatically start parenting time. So there's been no presentation about how the therapy is going, one. And I'm concerned about the timing of this renotice. We are in the middle of a pandemic. It's raging across America.
Joe.
And there's been no consideration about Ethan's health. We need to decide what is in Ethan's best interest. There's been no suggestion that it be Zoom visits, and I would certainly be objecting to any in-person visits until we have a vaccine, just for Ethan's health and Mr. Sharp's. It just seems like we're not really focused on what is in Ethan's best interest. It's all about what Mr. Sharp has done and what he wants to do. I need to, because it's my job, I need to determine what is in the best interest of Ethan. I don't think that it's in the best interest of the child to start supervised visits at this time. I'm encouraged by the progress we're making. I just think we need to make more before the court, and we need to hear more before the court can make that determination. Thank you, Your Honor.
How old is Ethan?
3.
Zoom visits with a 3-year-old, I'm sure can be challenging. Their attention span is weak. Would Ethan recognize his father?
No.
All right. The obvious purpose behind the requirements was that there be some verification that Mr. Sharp's mental health and behavior are under control. Simply providing releases doesn't answer that question. His representation that he's engaged with a therapist is certainly encouraging, but without something from the therapist to know, well, how's he doing? There's really no assurance given. So, Mr. Hurlbert, you got the releases. Did you seek to obtain copies of the records from those individuals?
Not at this time. I did have a conversation, as I said, back in March, I guess, when I was preparing for the original motion with Mr. Sweater, however you pronounce it. And then I got a letter from the other doctor. Where is it all? And it was the conversation I had with Billy that indicated that Mr. Sharp had turned a corner. And we did have a pleasant conversation. But I just think I got a letter from the other service provider. Physician assistant Mary Turner, providing psychiatric treatment for Robert. First seen in December, last appointment was February. Now, obviously, this was written back in March, so he very well may still be going. And just talks about him being compliant in treatment.
So what I think would be important for the court is to be able to hear from these folks, either through written reports or possibly through testimony. Clearly, those conditions were put in place not merely to check off a box, but to provide some assurance that Mr. Sharp's mental health and behavior are under control. I mean, I've personally observed Mr. Sharp's behavior in the courtroom on numerous occasions, and he's out of control. I've had to have him taken into custody because he wouldn't behave himself in the courtroom. I'm grateful that I now have the ability to mute his microphone so I don't have to listen to him spouting off during this Zoom hearing. But based on everything I've seen, I'm going to want to hear firsthand from therapists, again, either through reports or through testimony. And I am happy to schedule a hearing to do that. But that's gotta happen. There has to be something tangible that I can look at to see is, in fact, Mr. Sharp being compliant with treatment. I see that he's getting pretty agitated as I watch him on the monitor today, which is consistent with the behaviors I've seen in the past. He loses self-control so easily to subject a 3-year-old who's a total stranger to that kind of behavior is not something I'm going to do unless I've got some assurance that Mr. Sharp can restrain himself even for a supervised visit for a brief time. So, Mr. Hurlbert, I'm assuming you're being compensated through our fund here at the court.
Yes, Your Honor.
I think if you don't mind, I'd like to task you with obtaining the necessary medical records or reports and make sure those are available to the court. Mr. Jones, it would be incumbent upon you to call any witnesses on your client's behalf who can provide the court with assurance that he's capable of behaving himself for a 1-hour supervised visit. If I will have Dawn find a date for you, it'll be sometime in probably later September at the earliest. I'm getting ready to go on a medical leave of absence for a couple of weeks. But we will find you a date. Dawn will get a hold of you to make sure it works with both of your schedules, and we'll go from there. I'm certainly willing to give Mr. Sharp the opportunity to establish that he can be safe with this child in a supervised visit, but I gotta have some evidence before I do that.
All right, Your
Okay,
Honor.
we'll have Dawn get a hold of you. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Boy, do I love Zoom. Could you see the guy?
You looked agitated.
Every time he's been here,
So you had to take him to custody?
we put handcuffs on him and put him back. There's a holding cell back
yeah.
there, yeah.
Wow.
It's, you can come out when you can behave yourself, but even then he couldn't. I mean, the guy is just a rageaholic,
Is he?
yeah.
Wow.
Okay, let's see, where are we at? King versus Sharp, done. Freeman done, looks like that takes us to Airway.
Airway here. I just got this from Patty. It's a proposed order, but still no.
Yeah, that's not up for today.
Okay.
Okay, Rogers versus Rogers and Airway Welding. Counsel, are either of you expecting participation by clients this morning?
This is Joseph Spiegel. No, sir.
Your Honor, this is Bruce Inocencio. I do have my clients present with me in my conference room here, Doug Rogers, Jason Rogers, and Chad Rogers, but they are not going to be participating in the presentation today. And we are the only 4 people.
Okay, the reason I asked is there a couple, at least one person in the waiting room that's not identified, and I just wanted to make sure I let them in if this is their hearing. Okay, this
Your Honor.
is the,
Your Honor, I'm assuming that this is an error, but it says that it's streaming live on YouTube. And I think because the matter's addressing a sealed hearing, can you confirm that we are no longer live streaming?
Thank you,
let's
Mr.
address that.
Yeah.
Let's address that. We are live streaming, which I'm required to do when the courthouse is closed to make it a public hearing. Is this specifically addressed in whatever order I previously signed?
Well, it doesn't matter to me, Your Honor, but I think that the defendant's counsel had previously requested that the matter be addressed under seal, and this court had agreed that the matter would be permitted to proceed under seal. The order has not yet been entered by the court, and I know the court speaks through its written orders, of course, but in the interest of fairness, the court has indicated that the matter should proceed under seal, and I think it would be appropriate for Mr. Spiegel's position to have today's hearing withheld from live streaming. It doesn't matter to me. I mean, I just was trying to be considerate.
An order to seal documents is not an order to hold a closed court hearing.
I agree, Your Honor.
I understand, Your Honor. You know, because of the unusual situation, I appreciate Bruce's concern, and it is certainly my client's concern. We just don't want any more public information going out about this. It doesn't help my clients. It doesn't help Bruce or Bruce's clients. It's not in the public interest. And the order.
So let me ask this. I certainly am cognizant of the reason for concern. Is it possible to argue without getting into that particular, since I know what it is?
Sure.
That particular record that the individual involved in does not want made public.
We can do that from our perspective, Your Honor, absolutely.
I think we can do it also. And Mr. Bernard should be also part of this hearing.
Okay, hold on.
There we go. So he's also counsel for the Rogers.
All right, Mr. Bernard, I apologize. That's why I always ask at the beginning of the hearing, is there anybody else participating? I don't necessarily automatically remember who's all is on a file. So my apologies. So knowing that I'm aware of the underlying issue that you want to keep from a public record, go ahead with your arguments. Well, let me stop you for a minute. Mr. Inocencio, did you file a response to this?
Yes, we did, Your Honor. Timely.
I do not have it.
We will certainly send it immediately.
I had my law clerk look for it. He checked this morning on base. Whatever it is has not been processed at the clerk's office, and I've never been furnished with a copy.
Your Honor, we actually emailed that directly to your office as opposed to filing it with the court because of the filing of under seal. And so what we did is I filed a document with the court to indicate that it was sent to you via email only and not filed with the court for purposes of complying with the court's direction relative to it being filed under seal.
I've been watching my email to see if something like that came through. I didn't see it.
It was August 6th.
Did you send it? Did you send it directly to me, or did you send it to Patty?
1 minute, Your Honor. I can confirm that.
While you're doing that, I'll look in my email. That explains why it wasn't an on base. I didn't think of that.
Yeah, we did. We specifically withheld it from the court file.
Well, that makes sense. Hold on, let me look.
Sure.
You said August 6th?
Yes, I'm going to tell you here in 1 second if it was sent directly to you or to Patty.
Oh, I think I see it.
Okay.
All right, I want to take the time to read that, gentlemen.
We appreciate it, Your Honor.
Let me take a look at my docket this morning. All right, I'm going to take the time to review it now. We'll go off the record. I'll leave the meeting room open, but I'm going to stop the live stream.
Thank you, Your Honor.
Thank you, Your Honor.